day, everyone. I am Nicole Antoinette Castañeda, a fourth-year BSMA student. For today's presentation, we will tackle about law on business organization, partnership, and corporation, together with my partners Chelsea Vibar and Lance Garcia. To begin with, partnership. What is partnership? Partnership is an agreement between two or more parties as stated in the Article 1767. By the contract of partnership, two or more persons bind themselves to contribute money, property, industry to a common fund, with the intention of dividing the profits among themselves. Types of partnership. General partnership. General partnership, the most basic form of partnership. Limited partnership, partnership in which some of partners contribute only financially and are liable only to the extent of the amount of money that they have invested. In limited partnership, limited partners are shielded to the extent of their investment. Obligation to a partnership. A partner must contribute money, the medium of exchange, authorized or adopted by the government as part of its currency. If you want to contribute money, then you will be called capitalist partner. Property, any external thing, contribution of any property. Industry, diligence in the performance task. If you don't have money or property, you can contribute your skills and labor and become an industrial partner. Who can enter a partnership? Any person can enter a partnership, but partners should be a natural or legal person. What is a natural person? A natural person is a real human being. A legal person, an individual with legal rights and is subject to obligation. To be considered as a juridical person, a partnership must fulfill the essential requisites for a contract of partnership. So first, there must be a valid contract, oral or written contract. There must be a contribution of money, property, or industry to a common fund. Partnership must be organized for gain and profit. Lastly, partnership should have a lawful object or purpose and must be established for the common interest of the partners. Juridical person. Juridical person is an entity such as corporation created by law and given certain legal rights and duties of a human being. Example of a juridical person, A, B, and C form the ABC partnership. A partnership agreement, A, B, and C are natural person, and ABC partnership itself is a juridical person. In partnership, there is dissolution and winding up. So dissolution occurs when any partner discontinues his or her involvement in the partnership business, or when there is any change in the partnership relationship. And after that, there will be winding up. Winding up, this is when partnership accounts are settled and assets are liquidated. The partnership agreement is now void. General characteristics of a partnership. Consensual, perfected by mere consent, with a willing agreement with the partner. Commutative, contract of contribution of each partners contributes money, property, industry, or one in which each of the contracting parties gives and receives an equivalent. Principal, a contract that does not depend on other contracts' existence. Bilateral, contract entered by two or more, both parties agree to an obligation. Onerous, each partner must contribute money, property, or industry. This involves the promise of service or thing by a party which need to not be monetary but could entail other things. Nominate, a contract which has a name in law. A contract distinguished by a particular name, such as sale, insurance, or lease. Preparatory, contract in preparation for another contract. Doctrine of delectus personae. The right to choose with whom a person wishes to associate himself applied to show that partners have the right to select their partners and that no set of partners can take another person into a partnership without consent of each of the partners. So this is So this is it for the partnership.
So corporation. So first, what is a corporation? So corporation is an artificial being created by the operation of law, having the right of succession and the powers, attributes, and properties expressly authorized by law or incidental to its existence. So this is under Republic Act number 11232, known as the Revised Corporation Code of the Philippines, that took effect on February 23, 2019. So I mentioned that corporation is an artificial being. It is because it has a personality separate and distinct from the persons composing it, as well as from any other legal entity to which it may be related. Characteristics of a corporation. Corporation is an artificial being. It is created by operation of law. It has the right of succession. It has the powers, attributes, and properties expressly authorized by law or incidental to its existence. Next is the classes of corporation. We have the public corporation, private corporation, government-owned or controlled corporation, quasi-public corporation, stock corporation, and non-stock corporation. So, for the components of a corporation, first is that we have the corporators. They are the ones that composes the corporation, whether as stockholders or members. Incorporators, the stockholders or members mentioned in the articles of incorporation as originally forming and composing the corporation and who are signatories thereof. So we also have the stockholders and shareholders. They are the owners of shares of stock in a stock corporation. Next is the members. They are the corporators of a non-stock corporation. Board of Directors or Board of Trustees. The Board of Directors is the governing body in a stock corporation, while the Board of Trustees is the governing body in a non-stock corporation. So the number of directors shall not be more than 15, while the number of trustees can be more than 15. So, corporate officers. The president, who shall be a director, a treasurer who may or may not be a director, a secretary who shall be a resident and citizen of the Philippines, and such other officers as may be provided for in the bylaws. So, if the corporation is vested with public interest, the board shall also elect a compliance officer. Next is the subscriber. They are the person who have agreed to take and pay for original unissued shares of a corporation formed or to be formed. Next is the underwriter, a person who guarantees on a firm commitment and or declared best effort basis the distribution and sale of securities of any kind by another company. Lastly is the promoter, a person who brings about or causes to bring about the formation and organization of a corporation. So, articles of incorporation. So, what is the articles of incorporation? It has been described as one that defines the charter of the corporation and the contractual relationships between the state and the corporation, the stockholders and the state, and between the corporation and its stockholders. So that is all that I will be discussing about corporation.
Hi! Now that the general characteristics of a partnership and corporation has been introduced to you, let us learn more about them through knowing their distinctions. There are many distinctions that we can derive from a partnership and corporation. This video will provide you with 7 distinctions. To start, a partnership is created by mere agreement of parties. Yes, because a partnership is grounded by consent. The moment that the partners had meeting of the minds, then the partnership is formed. For a corporation, it is created by the operation of law, and it is governed by Republic Act number 11222, which is also known as the Revised Corporation Code of the Philippines. The corporation has more strict and legal sense compared to the partnership. Next distinction is that a partnership requires at least two persons to form a partnership. As clearly defined by the Civil Code of the Philippines, a partnership is whereby two or more persons involved. So there can be no partnership with only a person involved in a partnership. For a corporation, no minimum, but to the old corporation code, the minimum was 5, but not more than 15 incorporators. The no minimum person had its effect by the Revised Corporation Code in last 2019, and it had the effect also of having one person forming a corporation, which is known as one-person corporation. Next distinction between partnership is that it acquires juridical personality from the moment the partners have executed the contract. Yes, this is true because a partnership is grounded by consent at the meeting minds of the partners. The moment that the partners agreed and given their consent, then the partnership existence is formed. For a corporation, it begins to have a corporate existence and juridical personality at the time when certificate of incorporation is issued by the SEC. Yes, this is true because the definition of the corporation is created by the operation of law. From the moment the passing of requirements has been passed to Securities and Exchange Commission and the certificate is issued, then the juridical and corporate existence of a corporation is now being formed. The fourth distinction of a partnership is that it may exercise power authorized by the partners provided it is not contrary to law, morals, and public order. Inside a partnership, there are partners who we call as the managing partners. They are the ones charged with the management and the daily operations of the partnership. If no managing partner has been set, then all of the partners are the managing partners since they act as the agent of the partnership. In corporation, they can exercise only the powers expressly authorized by law or incident to its existence. The governing body found in a corporation is called the Board of Directors in case of stock corporation and the Board of Trustees in cases of non-stock corporation. Fifth distinction is that the partnership can run after the personal assets of a general partner in case of liquidation. In a partnership, there are partners also that we call the general partner and the limited partner. The general partner are the shock absorbers of the partnership. They are the ones that are subsidiarily liable to the partnership once the partnership cannot pay its obligation towards the creditors. The creditors can run after the personal assets of its general partners. Unlike the limited partner, they are only liable up to its capital contribution. In cases of corporation, creditors cannot run after the personal assets of a shareholder in case of liquidation. Well, generally, shareholders are only liable up to its subscribed shares. Next distinction is that partners' interest cannot be transferred without the consent of other partners. Yes, because the partnership is based on meeting of the minds and trust and confidence. The doctrine of delectus personae also applies in this type of distinction, since delectus personae allows the person to choose whomever he wants to be associated with, and no partners can be admitted into the partnership without others' consent. For corporation, shares can be transferred without the consent of other shareholders. This is exhibited by the eligibility of the shareholders to transfer shares without the other shareholders' consent. And lastly, the seventh distinction for partnership is that the partnership can be dissolved by the will of any or all of the partners. Since partnership is based on the consent of the other partners, the partners are not bound. The partners can dissolve the partnership by will, or those if the partners cannot anymore or cannot tolerate the activities or the activities of the partnership. While the corporation, it cannot be dissolved unless the corporation has the consent of the state, because the corporation is based on the operation of law. Thank you for watching our short lecture video about partnership and corporation. We hope you have learned something. Take care and keep safe.